我哋夠法定人數，咁我哋而家開會啦。我哋請團體代表入嚟先，同埋官員啦，好嘛？早晨啊，咁多位，本人謹代表呢，我哋法案委員會就係歡迎各位團體嘅代表同埋公眾人士呢出席今日嘅會議嘅。就2012年嘅稅務及印花稅法例另類債券計劃修訂條例草案呢係發表意見嘅。我亦都歡迎政府當局嘅代表呢係出席今次嘅會議。需要即時傳譯服務嘅議會人士呢，請帶上你哋嘅耳筒。並且按需要咧選擇呢個頻道嚇。座位上面咧已經顯示各語言嘅頻道㗎啦。今日共有7個團體係出席我哋呢個會議發言嘅，另外亦都有9位團體嘅代表咧，佢亦都唔會出席呢個會議，但係佢提交咗書面嘅文件嘅。我會先請各團體代表輪流發言，每一個團體嘅發言時間呢有5分鐘嘅。團體發言完畢之後，我會請政府當局呢係作出初步嘅回應。委員隨後呢可以向團體代表或者政府呢係提問嘅。根據慣常嘅做法，秘書處呢係已經將所有收到嘅意見書呢係上載喺立法會嘅網頁上面。倘若團體代表未有提交書面意見或者係仲有補充嘅話呢，就請盡快喺會後向我哋提交，好嘛？我亦都會提醒各位出席嘅團體代表，你哋嘅意見書同埋喺會上嘅發言，均不會享有立法會嘅權力及特權條例所規定嘅保障同埋豁免嘅。咁我首先呢就會請黎雅明律師行嘅黎雅明先生發言嘅。
Thank you. From my perspective, I really have 2 points to make. One is that I'm glad to see the way that it's been drafted, which is basically the shell contains the primary elements, allowing a great deal of freedom within the type of structure that can be formulated. The other point I'd like to make is that I think in the DIPN and the SOIPN, there should be some references to the materials, given that these are based on Islamic finance. There should be some materials allowing the commissioner and the collector to allow persons to refer to that. I'm not saying that you should mention Sharia or Islamic within that, but at least that would give confidence to those who are outside Hong Kong to understand that these are based on Islamic principles, but without necessarily referring to Islamic principles, because I agree it should be neutral in terms of the use of Islam or Muslim, which is understandable. And given the differences within the Islamic world, I think it's probably better for Hong Kong if we leave it neutral following England, and that would be easier for the way the instruments are structured. I've also got some other points on the possibility of records being kept in electronic form, and also the possibility under the stamp duty ordinance of having some sort of tax certificates, but without the interest element in it, as a means by which to deal with the security issue that's left in the other part. Apart from that, I have no further comments as far as I'm concerned from my company. Thank you.
Thank you. 咁咧就黎雅明先生咧，佢就係以一位獨立嘅律師咧係發言嘅。咁啊，佢亦都係律師會嘅代表。咁我相信佢剛才已經係表達咗佢哋嘅意見，同埋佢哋嘅意見咧，亦都喺書面上面咧都係好清楚㗎啦。咁啊，高志豪先生咧，佢就出席咗我哋嘅會議，但係佢又唔準備咧係發言嘅。咁相信我哋亦都會係睇到佢嗰個書面嘅意見啦嚇。咁下一位咧係花旗銀行嘅Mr. Usman Ahmed, please.
Good morning. Thank you very much for giving us the opportunity to be part of this effort. Just a quick introduction. I am the head of the Islamic banking business for Citigroup for Asia, and prior to that I was also the CEO for the global Islamic business based out of Dubai. We welcome this initiative. We think it is very important as a financial center, one of the global financial centers for Hong Kong, to have the ability to offer Islamic finance to both public and private sector enterprises, and to level the playing field by virtue of this bill. We do think that the flexibility that's offered through the various types of structures as contemplated herein will allow both the public and the private sector to tap the widest possible investor base, both from Asia as well as from the Middle East. We've been extensively involved with the recommendations process to date, and at this point we don't really have any specific concerns about any particular aspects of the bill. We think that should this be passed, it will encourage issuers from Hong Kong to tap the Islamic finance market in various formats, depending on the kind of assets that are available from their portfolio. There are, of course, certain structures that are more preferred in the Middle East than others. That has been highlighted, in the past. But again, this is a very fast-growing field, and there's a lot of innovation that has happened over the last few years. We have been involved extensively with bringing in first-time issuers from Dubai, from Bahrain, from Malaysia, Indonesia, even the German state of Saxony-Anhalt to the Islamic finance market. And the structures that are contemplated here, whether the sale and lease-based structure or the purchase and sale-based structure or the investment-based structure, they have all been used, including the agency-based structure as well, in various forms in precedent sukuk transactions. So we're very confident that these will continue to remain acceptable in the Islamic investor universe, and the specific application of these in the Hong Kong market should not cause any concerns for investors who are looking to also diversify from their home market and find alternative avenues for investment of their Islamic capital. Thank you very much.
Okay, thank you. 咁我哋都歡迎花旗銀行咧，另外一位同事咧係出席咗呢個會議嘅，就係 Mr. Oliver Goh。就一陣間如果有機會嘅話咧，佢如果有同事發問嘅話，佢都可以回應嘅嚇。咁下一位咧就係財資市場公會嘅張耀炯先生，張生。
Thank you very much for inviting me to be here today. The Treasury Markets Association has been following with interest the government's initiatives to develop Islamic finance in Hong Kong over the past few years. We are pleased to see the introduction of this bill into the Legislative Council, which is a positive and important step forward towards furthering the development of Islamic finance, and in particular, a sukuk market in Hong Kong. The Islamic financial industry has become an increasingly important part of the global financial markets, and by developing Islamic finance, Hong Kong can further diversify its financial platform and enhance its standing as an international financial center and an asset management hub. To provide some background, the TMA's Working Group on Development of Islamic Finance in Hong Kong had conducted a study a few years ago, finding that the sukuk structures, which typically involve the use of special purpose vehicles and multiple transfers of assets, may attract additional tax liabilities and stamp duty charges when compared with conventional bonds. Thus, suitable changes or clarifications would be needed to the tax laws in Hong Kong in order to provide a level playing field for the issuance of sukuks compared with conventional bonds. We note that the intention of the bill is precisely so, and we believe that the proposed amendments will help to align the tax and stamp duty treatment for common types of sukuk with their conventional counterparts, thereby providing a level playing field between the two. We support the proposed prescriptive and religion-neutral approach adopted by the bill, which has also been adopted in the United Kingdom and some other jurisdictions. We are also glad to see that after the consultation conducted by the FSTB last year, coverage of the bill has now been expanded to accommodate the agency arrangement. This structure is becoming increasingly popular in the sukuk market, and several landmark sukuk transactions from the Middle East and Malaysia have been structured using this agency structure in recent years. From a market perspective, we hope that the bill will be passed quickly so that market players can sooner make use of Hong Kong's financial platform to issue sukuk. Passage of the bill will remove a big impediment for issuers considering to issue sukuk and will also open up more options and opportunities for market players. Thank you very much.
Thank you. 下一位係香港中銀資產管理有限公司行政總裁歐景麟先生，歐生。
係主席各位議員同埋各位朋友我哋好支持呢個草案嘅。咁我係想講一講咧，我哋係用一個market practitioner 個角度去睇呢個草案啦。因為其實我哋覺得個時間咧係相當之好嘅，因為其實大家都見到呢個人民幣國際化咧係行得越嚟越快嘅。咁喺我哋嗰個 submission 嗰度咧，我哋講咗有兩個原因啦。其實一個就係咧如果喺一個大圍嘅環境睇咧美國喺能源嗰方面咧，喺好多方面咧，亦都有個估計。其中一個係BP 咧，喺舊年咧出咗一個 report 咧，都幾震撼嘅。佢哋就係估計咧，美國喺2030年嘅時候咧，已經可以咧係完全自己喺呢個能源嗰邊獨立㗎啦。咁如果你睇翻呢個發展咧，喺中東嗰方面咧，佢一定要揾另外一個buyer 啦，個 customer。咁你可以睇到咧，中國係而家已經喺能源同埋喺呢個commodities 嗰方面咧，有一個最大嘅 consumer 啦。咁所以我哋覺得咧，中國同埋中東嗰個關係咧，只會越嚟越密切。咁喺 McKinsey 咧，亦都有個projection 咧，喺2020年咧，嗰個 trade flow 咧係講緊大約350至500個 billion 嘅。其實我哋覺得呢個可能係一個 underestimate 添，underestimation。咁點解我哋覺得呢一個標係對香港好重要咧？就係因為大家都知道，其實香港已經係一個人民幣嘅交易中心。咁我哋都好積極咧去發展呢個點心債呢個市場。咁但係如果當中國同中東嗰個交易咧個量越嚟越大嘅時候咧，咁亦都咧相信咧好大部分呢一個將來嘅交易咧都係用人民幣交收嘅。咁如果人民幣交收嘅之話咧，就係中東嘅投資者咧手上嘅人民幣會越嚟越多，咁你哋都要需要投資嘅產品。咁所以我覺得如果呢個草案過咗之後咧，香港咧喺呢方面咧發展嘅潛力係會好大。咁亦都相信咧，亦都好多中資嘅公司亦都想喺中東去發展。咁如果有呢個 Sukuk 呢啲咁嘅產品出現咧，咁亦都會幫助到咧呢個capital market 嘅發展。咁所以我覺得香港如果過咗呢個草案之後咧，咁我覺得香港嗰個喺人民幣嗰個國際中心發展咧，唔單止淨係好似而家咁嘅規範，可能亦都會發展到咧去Islamic finance方面。係。
好啊，多謝你歐生。我哋下一位係九龍清真寺香港總教長嘅艾爾沙特先生 ，Mr. Asher。
Thank you very much. Good morning. I am grateful for inviting me on this important meeting, and I would like to tell about the basic difference between conventional banking on bonds and sukuk. Islamic religion has introduced an economic system to the world, and that has been practiced for last 2 decades, and more than 200 financial institutes are doing experience on Islamic finance. And Islam has forbidden to deal with the usury or interest. This is the basic law of the religion of Islam. And the second important aspect that there should be no gharar. Gharar means there should be no speculation in the financial system. No artificial money is allowed in the religion of Islam. And in Islamic faith, the dealing, trading in the debts are not allowed. The Islamic sukuk is a product that is based on actual product, actual things, not only dealing with the debts. So this is the basics in the Islamic finance. And sukuk is one of the product, not the complete Islamic finance. And if we see in the Hong Kong, it is a great market for the Muslim as for the non-Muslim. For the Muslims, they are bound to deal as per the instruction or the guidance of the faith or the religion of Islam. So according to Islam, a Muslim cannot deal with usury or interest. So for them, there is a limitation, especially in Hong Kong. But if you adopt the Islamic finance, indeed there will be an opportunity for the Muslims as well as for others to make the business, to make the deal. So the first and the most important thing that I appreciate for the government who is introducing the Islamic finance in Hong Kong, indeed I hope, as you have seen in the past few years, worldwide, there will be turmoil in the economic system, in banking. It was because of artificial money. It was because of trading in the debts. So Islamic finance was saved in the past. So it should be adopted. And the most important thing here in Hong Kong that we need that is the mortgage, Islamic finance, because there are a lot of product in Islamic finance. One is the sukuk, one is the takaful, that is the equivalent to the insurance, and one is the baysalam, and one is the istisna, and one is this mortgage. The mortgage, again, it is the protection of the bank as well as the protection of individual. So it should be adopted. So Islamic finance believes in profit and loss sharing, not only sharing in the profit. So Islam also gives the benefit for both parties. So it should be adopted in a way so it is beneficial for all. Another important point is Islamic finance sells the commodity when it comes into the position. If someone has no position, then he cannot trade. So it is again a protection for the parties, and purchasing and selling of loan is also prohibited. Islamic finance says that no gain without either efforts are liability. So if it is adopted here, I believe many Muslims will get benefit, as well as the other people will have a chance to make money through this thing. And I believe and I am grateful for the government of Hong Kong for introducing this bill. Thank you very much.
Okay, thank you. 下一位係至善培訓及教育機構嘅何麗儀女士。
Good morning. We have submitted our view and we have no further addition. However, I would like to highlight that Hong Kong is in need of well-trained finance professionals to work on this alternative bond and the subsequent Islamic finance products if there is any in the future. Manpower development in this respect should be part of the plan in the introduction of this initiative. The administration should give recognition to suitable qualification, both training and practical. Thank you very much.
Thank you. 好，政府有冇咩回應啊？
多謝主席。如果主席容許我，或者用英文作出一啲簡單嘅總體嘅回應，或者一陣嘅討論，我哋睇下嘅情況。Like the chairman, I would like to take this opportunity to thank for the speakers who spoke just now, and those organizations and persons who have submitted written submissions to the Bills Committee, expressing their views on our legislative proposal for the introduction or to remove existing hurdles for the development of Islamic finance in Hong Kong. At this stage, the development of a sukuk market in Hong Kong. So from our point of view, I must express our appreciation for the overwhelming support we heard just now for this legislative initiative. I think that sort of overwhelming support based on three reasons. First, there is actually a need on the ground for the development of Islamic finance, especially in Hong Kong as an international financial center. That market development presents us with a very good opportunity in terms of timing. We have just heard about from the market practitioners how they see the development of this market now vis-a-vis the development of Hong Kong, especially the development of Hong Kong as an offshore renminbi center. We think that this is a very good marriage of various factors leading to the Hong Kong's unique position and advantage in developing this market. The second point is we do recognize there are hurdles on the way, and the biggest hurdle now is in the taxation regime that we have that may put Islamic bonds or sukuk, because of their unique characteristics that has been just very well explained just now from what we heard, that may require some changes in our legislation so that they will develop on the same footing as other conventional bonds from the taxation perspective. So along the way, in order to achieve that objective, we do have to think of the best approach in terms of drafting the legislation. And I'm glad to hear that there was support expressed just now for the proposed legislative framework we have put in the bill, mainly by putting the various sukuk structure and nature in the principal legislation and setting out the conditions. But some of those conditions will be further explained in the DIPN to be issued by the taxation authorities. So we took note of some comments on the need for some reference to the characteristics of these products or the bigger context in the DIPN. We will duly consider these suggestions while the taxation authorities draw up their practical guidance note on this respect. The third reason for, I think, the support we heard, of course, I would, of course, hesitate to mention that on the individual comments on the drafting of the bill, on the very specific wording. I think we can also take the opportunity of the Bills Committee's scrutiny process, ensuing process, to look into them in further detail. But I would just state that the third and last, but not the least, reason for the support perhaps is that we have admittedly taken some time in drawing up the proposed legislation since the first idea or the concept was mooted with the market, because there are quite a lot of complexities and technical considerations involved. And also we have taken time to consult the market with professional organizations or with individual market practitioners during the process before we actually put pen to paper in drawing up the bill. So we of course put out public consultation earlier on, and we received very useful comments. And in the form of the bill, we see or have been presented to the Bills Committee. Actually, they have reflected quite a number of comments received from the market or commentators during the consultation process, mainly on the coverage that some speakers have just mentioned. We expand the scope of the coverage of the Sukuk products. And talking about, I think one speaker just now commented the bill allows flexibility. That is true, because even in terms of coverage, we build in some flexibility in the bill so that if market development requires so, we can, with the FS Financial Secretary's authorization and with the electrical approval, we can introduce further products type under the bill. So similar flexibilities are built into the bill. And other comments we have taken into account regards those, for example, other record-keeping period, limitation period, etc. So I think I would just leave the time open for further discussions, and we look forward, as speakers comment, a quite speedy scrutiny of the bill with the Bills Committee, so that we can have this tool and infrastructure for the Islamic community and the wider community, as well as the professions working in this area, so that they can really embark on more initiatives in this respect. Thank you, Chairman.
Okay, thank you. 唔該晒秘書長。李慧瓊議員。
係，多謝主席，亦都歡迎今日嚟參與我哋會議俾意見我哋嘅團體。普遍頭先政府嘅回應都係團體裏邊發言嘅內容，大家都係對於呢一個草案呢係表示歡迎，亦都相信呢會有助推動香港伊斯蘭金融嘅發展。咁我都留意到呢有部分今日冇嚟參加表述意見嘅團體都有啲書面嘅意見，主席。咁呢其中有啲會計師行啦，同埋Law Society 咧都表示有啲問題。咁我都想請教下今日嚟表達意見嘅團體同埋政府對於呢啲嘅內容嘅回應。咁其中一個呢，就係大家都不約而同咁樣去對於草案裏邊有一個要求，就係叫 reasonable commercial return condition， 就認為係好難界定嘅，亦都有意見認為呢就要將佢刪除嘅。咁究竟呢個你哋嘅理解是否係一致呢？同埋有冇啲咩意見可以俾到我哋同埋政府呢？另外就係嗰個關於嗰個 maximum term length condition of 15 year， 咁亦都有意見認為呢就係未必係需要有呢一個 maximum term length 嘅 condition 嘅。咁我想聽下團體嘅意見，有冇團體願意回答呢？嚇？唔該。
好啊，有冇邊位想表達下意見？黎雅明先生呢，就喺佢嗰個意見書裏邊有提到呢個問題嘅。
The law side has actually already made its comments on that, and they've suggested in relation to reasonable return, I think that's something that needs some consideration. Also to the period at which the some sort of deposit is to be kept. I think that is also something that needs consideration because of the long-term effect of that. No solutions have been suggested, but I think the Law Society's views on paragraph 4 clearly after having a meeting with the Law Society, that was the concern of some of the members. And I think that needs to be addressed in the bill or perhaps the relevant DIPN or SOIPN to make it clear. Otherwise, it would make it difficult for those people wishing to introduce products, and it could actually be a disincentive. So I think that's a crucial element that needs to be considered. The law side has also looked at some other elements, which I'm not repeating, which is about definition about material time, because the arguments are rather circuitous, but in relation to the comments just made, yes, law side has considered that, and it's of the view that the administration should look at that carefully.
Thank you. 歐生會唔會有啲咩意見？即係喺呢個 term 嗰方面咧，即係你哋就做呢個資產管理嘅，咁將來如果真係要發行呢一個咁樣嘅伊斯蘭債券嘅時候，你覺得有冇咩問題？
主席，我覺得如果個年期可以隨面嘅，梗係最好。另外一個嗰個頭先話嗰個 reasonable return 嘅 definition，我都同意。如果嗰個可以清晰啲嘅咧，咁變咗市場運作嘅時候會知道嗰個框框喺邊度。
好啊，其他朋友有冇咩意見啊 ？Mr. Oliver Go，
一個補充，嗰、那個 reasonable return 咧，即係因為頭先提到咧，因為 Sukuk 嚟講咧，佢安排咧係需要有個 feasibilities 嘅。咁往往咧，佢嗰個 financial arrangement， 因為咧佢唔可以計個利息嘅 interest， 咁變咗咧可能咧係喺個 arrangement 裏面咧，可能 at a discount， 或者咧係一啲 in form of 一啲 additional charges 或者個 banking charges， 咁可能你喺個 taxation 裏面啦有個 substance over form， 咁因為如果你一用 substance over form， 你好難做落去嘅，咁變咗咧，我諗呢度可以大家考慮下咧，就用一個 reasonable terms 嚟包括咗佢，反而咧可以係後面咧喺實施嘅過程裏面咧，按照個 case 咧喺 departmental interpretation notes 嗰面啦 DIPN 裏面咧來將佢細化咯，即係呢個係我呢面嘅意見。
好啊，有冇邊一位想表達意見？李慧瓊議員。
我多謝大家嘅意見啦。我諗呢部分我哋喺再逐條審議嗰陣都會去跟進。不過另一樣亦都想請教大家，因為今日都有好多業界嘅人士，我自己當然非常之希望可以推動伊斯蘭金融喺香港嘅發展啦。但係從資料上或者從我個人嘅觀察呢，就係其實香港我哋冇相應嘅文化啦。比起其他一直已經發展得好蓬勃嘅地方呢，可能我哋相關嘅條件並不是完全具備嘅。咁我想聽聽業界喺呢方面嘅睇法，即係頭先大家都好正面。咁除咗呢個法例之外，其實政府有啲咩需要再做，去令到伊斯蘭金融嘅發展可以進一步係喺香港擴大呢？
邊一位可以講講？歐生。
或者我答議員呢個問題啊，因為我頭先講話呢個草案呢個timing 係好好，時間係好好啊，因為即係人民幣國際化咧，令到好多外國嘅投資者咧對人民幣好有興趣。咁金管局咧年初時亦都去過中東啦，推銷過人民幣啦。咁跟住之後個反應都好好。我哋公司自己咧都有不同嘅中東嘅機構咧，係邀請我哋過去咧，去同佢哋去講解咩叫做人民幣國際化，同埋投資嘅機會喺邊度。咁因為而家香港係冇可能出到 Sukuk 啦，咁其實嗰個需求唔單止係美金嘅，人民幣嗰方面嘅需求咧係會越嚟越大。咁所以我哋覺得頭先我亦都講過就係個發展個空間咧，我覺得自己可能喺人民幣Sukuk 嗰方面咧個發展個空間就更加大添。咁所以頭先答咗議員咁多，以前咧可能香港係想做呢個Islamic Finance 咧係個條件可能未必完全充足嘅。咁但係我覺得再向前望咧我哋個機會係好大，因為如果環顧可以做到一個現時嚟講啦，一個人民幣嘅債券市場嘅中心咧，香港暫時都仲係有優勢嘅。
好啊，
有冇邊位高生？
係，咁我簡單再補充一下啦嚇。頭先提到，咁咧就我哋我覺得2008、09年咧，就馬來西亞政府咧曾經嚟香港咧就推廣過一次嘅， 但係咧就好多人過咗去之後咧，就好似個感覺咧係有少少Islamic finance 係無疾而終嘅。咁點解咧？就因為好多個平台未出嚟。咁我今次咧呢個stamp duty 同 inland revenues 咧，就基本上咧就係大大咧減低咗個交易成本個 transaction cost。咁點解咧？因為你有個 Islamic finance 上面有個 transfer of ownership 啊。咁因為呢個嚟講咧，就 in substance 咧係要交多一次稅嘅。咁我哋呢度咧就立灣咧作為馬來西亞咧係第二金融中心，上面係立灣 Financial Service Authority 啦，再上面係財政部嘅。咁咧我哋下面咧就有個交易所，立灣 International Financial Exchange。咁馬來西亞咧就佔全世界嗰個 Sukuk 咧個發行量咧係7成嘅喺今年嚇。咁咧就我哋依面咧亦有好多人才，咁我相信咧係有呢個基礎咧可以同香港政府包括呢方面咧係直接嘅合作。咁我提到咧就第二樣嘢咧，我哋嗰面咧就係亦係有人民幣嘅債券嘅發行嚇，有一間咧叫 Dunga Capital 咧係有5億人民幣嘅發行。咁馬來西亞政府亦積極咧係做一個人民幣嘅 settlement。咁另外咧亦除咗一個 alternative 咧，亦通過歐山嗰邊嘅中國銀行咧喺吉隆坡嘅辦事處咧嚟做一 settlement， 即係話咧我哋係可以經過 Ben Nagara 嚟做人民幣 settlement， 同埋中國銀行香港嚟做 settlement。咁另外咧一樣要提翻咧就係話有一個案例就係喺香港聯合交易所嘅個 stock code 係4320，咁係馬來西亞一個手提電話公司嚟嘅，咁佢嗰個 bonds 咧係立 bond 嚟listing 嘅，而同一時間係 dual listing 咧喺香港嘅。我相信咧，大家頭先提到因為未實現過啦冇案例咧，咁可以參考呢個4320咧，呢個馬來西亞公司而喺香港咧係掛緊嘅招牌掛緊嘅，咁可以咧係嘗試摸到或者係發現到一啲現有或者係已經操作到可以學習到嗰個嘅問題嘅。咁最後咧，我有幾個新聞啦，可以或者喺 news status 咧，同大家可以分析下講講嘅。立灣咧，除咗係國際金融中心之外咧，嗰度咧係第二我哋主要貿易咧就係國際石油貿易嘅。而頭先亦提到咧，有好多咧，因為馬來西亞而家商人咧比較早咧喺中東嗰邊嚟做石油貿易，我哋嗰度咧亦係有好多係中東嘅石油商咧係嚟註冊咗係做緊貿易嘅。咁所以咧呢度咧會有好多 oil money， 咁可以俾到香港政府咧係一個啟發，呢個第一樣嘢。咁第二樣嘢咧，而家咧就係馬來西亞咧，除咗咧一直咧係嗰個 US 嘅 settlement 之外咧，而家係積極咧嚟做嗰個人民幣嘅 settlement。咁咧就仲有兩點啦嚇。第一喺5月18號2012年咧，咁咧就 Ben Nagara 嗰面咧已經喺北京嘅馬來西亞大使館個網站公佈咧，就係有11間銀行，而家已經有17間銀行咧嘅馬來西亞咧係已經可以用一個 system 叫 MyClear 咧進行嗰個人民幣結算。而同一時間咧喺2011年嘅11月咧，就中國政府嘅商務部咁啊，裡面咧已經係可以咧就係經提到咧就係話咧，如果你係有一個 overseas 嘅 renminbi 嘅 equivalent 咧，你可以嚟作為一個現金投入去中國投資啊 ，provided 咧你商務部係認可嘅。咁所以咧就係話呢啲好似係點心幫或者係 offshore bonds 咧，係將來咧係直接咧可以幫到所有商人，包括政府同埋推動咧呢個人民幣嘅國際化嘅。所以我想希望大家咧在座咧可以認真考慮呢樣嘢對香港政府吸納嗰個中東嘅資金，同埋咧馬來西亞因為好近香港，可以好容易咧係交流，同埋 create 到一個 test substance。咁變咗咧，希望咧喺稅務嗰面咧可以同埋所有嘢咧可以雙方咧係多啲嘅交流。咁聽日咧亦係香港金管局咧同 Ben Nagara 咧喺香港咧會有個會議嘅嚇。咁主要係咁樣，唔該。
好啊，多謝你啊，高生。咁啊，馬來西亞喺呢一方面嘅工作咧做得相當好嘅嚇。啊，梁繼昌議員。
多謝主席。Mr. Chairman, I've got quite a number of questions. The first question is a factual question. But before I ask that, I think I welcome the tabling of this bill by the government, and I also support the bill. although I comment, I would like to make is that maybe, although I noted that Ms. Lina Yan said that the government has taken some time to do the consultation for the past couple of years, I do think that the bill is a little bit late, but late is better than never. First question is just a factual question. Maybe all the guests here could give me some information on that. I would like to know the Muslim population in Hong Kong and also the Muslim population in mainland of China. Is there any, maybe the government can also give me this piece of information as well. Is there any statistics on the Muslim population in these two jurisdictions?
Go Sang. Go Sang.
After
Okay. Yeah. Yeah.
Can I? About the Hong Kong Muslim population, it is estimated 200,000. And about the mainland, I don't have information, but indeed there are more than that population living in China. And also the area close to Hong Kong, Guangdong, Shenzhen, there are many Muslims, businessmen who are settled here in the China. They come for the business. And there are many companies of Middle East now, they have opened their offices here in Hong Kong. And they want to start the business in Hong Kong by Islamic finance. So the local permanent resident, they are about 200,000 living in Hong Kong. Okay. That is my estimate. Maybe it is different from the official statistics.
Okay, thank you. Go Sang.
Okay, I got this figure from two sources. The first one, I read a report 5 years ago. It mentioned that the Muslim population in China is about 22 million. And secondly, I met Ningxia government with our Deputy General Director in Beijing, and he mentioned that no official figure on hand, probably less than 30,000 million. And as far as I know, besides Xinjiang or Muslim, there are 6 million Chinese, 6 million people in Ningxia, and among that, 1/3, that means around 2 million Chinese Muslim there in Ningxia autonomy area. And in Henan province, just in Jingzhou, the capital of Henan, there are 1 million Chinese Muslims. Yeah.
Yeah. Okay. Thank you.
Note that in Malaysia, when Islamic finance started, at one point, the non-Muslims were investing more in Islamic finance than the Muslims were because of the.
I just like to say that the main market is not just Hong Kong and China. I think it's the whole of Middle East. Just to give you an example, there have been a lot of demand for QD. Just a couple of sovereign wealth funds in the Middle East recently got a $1 billion quota, and just one institution. And so it's not just a number of population, it's really the quantity of money that is really the driver.
Eddie, go. Eddie.
At the time I met the Ningxia government. There are Chinese Muslims in Beijing, and also they met Ningxia government. They mentioned that it's good to raise the wholesale Islamic bonds through Hong Kong. And that's why I suggest the Hong Kong government to do more communication roadshows to the Ningxia people in Beijing and also in Yinchuan. And for the retail one, in 18th of May 2012, the third bank of Ningxia government, 十九三银行, 十九三 Bank, had cooperated with a bank in Malaysia, a retail bank in Malaysia, and approved by Bank Negara. That's why I think that I talked to the first and second Islamic bank in Ningxia, and they're still planning for that. That's why I suggest the Hong Kong government to do more things to them. And the head of these two banks, the government officer of the Ningxia autonomy region at the same time. Yeah, that's all.
Okay. Mr.
I think it's also important to note that it's not just Muslim individuals, but as the number of Islamic banks and takaful companies increase, then there is a greater demand for them to be Sharia compliant, and therefore they are looking for products which are Sharia compliant. And therefore it's a snowballing effect in the sense that the greater number of institutions and those institutions looking for investments and, of course, bonds. So I think that's an important part to look at.
Okay.
And Hong Kong would be ideally suited because it's an international center, and institutions around the world, as the numbers increase, there will be a greater demand, and Hong Kong would then be able to service those, and therefore it's not directly related to individual Muslims alone.
Yeah. Okay, Mr. Ahmed.
Thank you. Just a couple of points to add on what has already been said. When it comes to institutional demand for Islamic finance, I think it's important to realize that any institution that intends to tap the Islamic finance market, either by virtue of sukuk or other structures, can attract Islamic liquidity from anywhere in the world, as long as the underlying structure and documentation meets the requirements of the principles of Islamic finance. So the actual liquidity pool that can be accessed is not dependent just on the domestic liquidity coming from retail investors from Hong Kong or from mainland China. It would in fact be primarily directed towards attracting liquidity in the Middle East as well as in the Islamic centers of Asia. Then when it comes to the retail market, the consumer market, of course, for those, for that particular segment, having Islamic deposit and asset products would give the individual consumers the choice and the ability to invest in line with their own sort of beliefs and their own faith. So for the wider, I think, proposition, what we're really hoping is that this initiative will enable Hong Kong-based corporates as well as Hong Kong listed transactions to attract the vast pool of liquidity from investors who only invest in a Sharia compliant manner. And in all the transactions, the sukuk transactions that have been done across the world, we've seen that it has proven to be the most inclusive way to tap the market, because not only can you attract the Islamic investors, but even the conventional non-Islamic investors are, welcome to invest in the same transaction.
Okay. Thank you. Ho Chiu-jie.
In fact, in answer to Ms. Lee's question, there are a few things the administration can do to promote Islamic finance. The administration should have an overall strategy to promote a broadly comprehensive Islamic finance product such as takaful, trade, finance, and wealth management, in order to give more choices to investors and enhance Hong Kong's wealth status as the financial center. Secondly, the administration should promote these because Islamic finance is not religion-bound. 65% of the consumer are non-Muslim. So I think the administration can also promote this concept to the investors. In order to make this a success, I think we need to really look into the education side and training side so that we have enough talent to support our initiative. This is our view.
Okay, thank you. Chun Sang.
Just to add to the the discussions, if we look at the interest in Islamic finance throughout the world, that's been increasing right across, not just in Muslim countries. So if we look at the interest in Europe, for example, led by London, and we've also seen the French also look at it. And in Asia Pacific, for example, we've also seen the Japanese, the Koreans, as well as in Australia, efforts have been made to actually introduce changes in legislation to effectively provide users of finance the ability to tap also into the liquidity that the Islamic markets do provide. So from that perspective, I think there is, it's quite imperative in respect of this development that the Hong Kong government actually looks at this quite closely, and to bring this bill forward to join the rest of the global community in this respect. Yeah.
Hi, thank you, Chairman. Just two follow-up questions, both on the market itself. Could our speakers today just walk me through in further detail, because I understand that there are quite a number of sovereign wealth funds who would like to make investment in this part of the world, Hong Kong and or mainland China, particularly in real estate sector. Can someone enlighten me as to how the development of the sukuk market in Hong Kong can help or facilitate these sovereign wealth funds or financial institutions to make investment into Hong Kong or China? That's my first question. The second question relates to a comment made by Mr. Asher just a few minutes ago. He mentioned about Islamic mortgage. I just want to address this question to the Hong Kong government. Are there any regulatory or taxation hurdle which would prohibit the introduction of Islamic mortgage product in Hong Kong? These are my two questions. Thank you, Mr. Chairman.
Okay, thank you. Mr. Ahmed.
In relation to your first question, I think Islamic finance can be instrumental in two ways in attracting sovereign wealth funds to invest in, particularly in the real estate sector in Asia and in this in Hong Kong and mainland China. Firstly, a lot of investors prefer for the underlying stock or the shares of the companies that they're investing to be Sharia compliant. And there's a certain set of rules that have been accepted and by international index managers, for example, the Dow Jones Islamic Index, wherein no more than, say, 1/3 of the debt that is taken by a particular company can be non-Islamic or interest-bearing debt for the underlying stock to qualify as being Sharia compliant. Therefore, for maintaining Sharia compliance of the equity, it's important to be able to leverage a particular investment on an Islamic basis. And that's where the significance of Islamic debt and instruments like sukuk comes in. And then, of course, in addition to that particular benefit, which would create more liquidity in the underlying stocks because there's a greater investor following, the other advantage is that by structuring the debt on a, if I may use that term, on a Sharia compliant basis, we are able to tap the widest possible investor base, as I mentioned earlier. So the ability of those transactions to be executed successfully at the best possible pricing is enhanced by having those underlying transactions structured to be Sharia compliant.
Thank you. Mr. Nasser?
As I said, I like the way in which this ordinance has been drafted, in the sense that it gives you the essential features but leaving everything else flexible, and therefore I think it would be easier for those who structure these within the bill to be able to do that, as well as comply with the provisions of the ordinance. And so for that perspective, I do like its flexibility in the sense that it retains, actually there must be quite a lot of research done. It's amazing that not having a Sharia scholar, I'm not sure they had a Sharia scholar, but they've actually distilled the key features that are required in order to put together Islamic structure, but left all the other details out, and therefore it will provide some flexibility there.
Okay. Ousan?
Yes. Just want to go back to the theme of renminbi internationalization, just answering the question whether the sukuk development would be useful for investment. In fact, it's not just a one-way traffic. As I explained earlier, that with the trade between China and the Middle East increases over time, there will be excess renminbi being accumulated in the region, and for those Middle East investors who are for religious reasons want to invest in Sharia investment product, then we need to provide them with that vehicle. But from a corporate perspective, by raising offshore renminbi through sukuks, it will facilitate that foreign direct investment into China. As you know now, there's a policy differentiation between dollar FDI and renminbi FDI. I don't want to go into detail. We don't need to here. But and further down the road, you also mentioned where the Swiss, the sovereign wealth fund making investment in China. I think for several reasons. I think ultimately the goal we would like to see is to have renminbi being treated as a reserve currency. And for that to happen, you need to have a matured capital market to provide liquidity. And that's why the development of the Sukuk is so important, in my view. Thanks.
Okay. Mr. Edigo?
I try to sum up your two questions into 2 points. One is the compliance. The second one is costing. For compliance, all Sukuk need, in Malaysia, all the Sukuk issued need to fulfill SARA principle and those with professional people from SARA bodies. So I would suggest Inland Revenue, in order to speed up the issuance of Sukuk, I would suggest the Inland Revenue Department to include such a professional body or professional people into your committee team, or even in the DIPN college there, and to speed up the compliance issues, and also to the other commercial institute as well. And secondly, for your point, property, for some of the case that would include hotel projects. I recall that hotel is not allowed to be included in the Sukuk. So if yours is only a property project, that's good. But if it includes some kind of a hotel element, so it should be excluded. For other exception interests, I don't want to mention here. And the other one, mortgage. For Sukuk, interest element is not allowed inside, but probably you can repackage it as some kind of discount issues or other banking charges arrangement, as I mentioned before. So I think commercial institutions need to be aware of those terms and the promotion. That will be quite strict from the SARA's principle and Islamic principles. Very strict. And also propaganda promotion as well. And finally, I want to bring out a business case from Iraq, not Iran, Iraq. I read from a book that after the U.S. entered into the Iraq, there would be a huge demand in Islamic finance there. And the Islamic finance arrangement in Iraq differs from province. So that would bring me another view to China, because Chinese central government said that Islamic finance would be in Ningxia, Yinchuan. So I'm not sure whether in the future whether the Islamic arrangement in Ningxia or Yinchuan will be different from other provinces from China. So I think that I would suggest IRD aware of this point and try to create feasibility as far as possible. But at the same time, I think that will be, I foresee that there will be a conflict or maybe difficulties in terms of jurisdiction and tax substance. Yeah, that's why.
Mr. Azad?
Yeah. Yes, actually, these two questions is not related to me. The government or some expert in the institution can answer. But for the basic, the mortgage, conventional mortgage and Islamic mortgage has a difference. In Islamic mortgage, the individual or bank, both are the partner in the property. Like if an individual pay 20%, he is the owner of only 20%. Against the conventional way of mortgaging, that the bank give the loan. In this way, it is not allowed because it is interest based. So the Islamic way, he is owner of only 20% or 10%, whatever he is paying. The rest is the rest owner is the bank. Then the bank give on on rent basis to that individual. At the end, when the bank receive its cost or with profit, then with the last installment, he sell this the 80% portion of that property to the individual. So in this way, religiously, it becomes okay, and individual is happy, and also the bank is safe.
政府有冇咩回應啊？
I think under the bill, of course, if property transactions are involved as part of the structure for Islamic sukuk, the bill actually seeks to exempt them from stamp duty. But going back to the Islamic or mortgage issue, I think I heard what Mr. Koh explained it in very well terms, and also the chief imam also explained in Hong Kong. So systemically, we are not sort of seeing problems brought to our attention per se, but we are open to look into it if there are any taxation issues that may be involved in that respect. But if I may just take the opportunity to respond to the various call for the promotion and contact with other authorities in promoting Islamic finance in Hong Kong. I think we do very much value the opportunity to go into contact and learn more from the Malaysian authorities. And I think, thank you for the very good advice that we should also step up contacts with other parties, including the Ningxia and Yanquan authorities in that respect. So, and also we will look into the sort of professional training situation to see whether there can be strengthened partnership of various entities involved. Thank you.
梁議員長問。
多謝主席，我冇再有其他問題，唔該。
好，石禮謙議員。
Thank you, Chairman. Chairman, I'd like to ask Imam Mufti Ashad to enlighten us. This legislation is neutral as to religion. Can this type of legislation be practical, that be neutral to religion, and how does this compare to other Malaysian similar legislation?
If it has been made the law in Hong Kong, I believe it will be good for everyone, and it will not be binding to any party to deal with Islamic finance, but it is an opportunity for those who want to make business or deal or want to get the house through Islamic finance. So it is a facility, I believe. And also the same time, it is in the past few years and in many words, in many countries of the world, it is proven that it is a safe transaction finance, and it is good for everyone. Actually, the Islamic finance is not only for the Muslim. Like it has been adopted in UK, as it has been mentioned, and some other in France and some other non-Muslim countries. So it is a facility for the resident and for other people who want to invest in Hong Kong, and they are Muslim and they want to make a business in Islamic way. So that would be a good chance and good opportunity for them.
No, my question is, because this legislation is neutral in terms of religion.
Yes.
But my question is, actually, I just seek some understanding. How can this divorce from the Sharia, from the Islamic law, when you have such a instrument? Can it be in this legislation? Do you see this it being successful, being neutral to religion? That's my question.
我哋問問Mr. Nasser.
If I can help, as I said earlier, the we've got the specific products, the contracts that are mentioned here. What they've done in this legislation is extract the primary elements of those products, and therefore it's Sharia compliant in the sense that it is broadly accepted that those are the essential characteristics of those contracts. For instance, if it's a wakala, it's agency, and therefore it's agency. If it's a musharaka, then it's a partnership. And therefore, if you look at those specific contracts, under Sharia, those specific elements for those contracts have been incorporated in the ordinance. But all the other detail has been left out, and therefore, I think it's flexible enough, and therefore it's compliant with Sharia to that extent. Anyone looking at it would say, ah, yes, the primary elements within each of those contracts are there. Whether or not there's going to be compliance would be up to the Sharia scholar, but he would look at the details. And the details, which I've said hopefully would come under DIPN. But as the primary elements are concerned, they're within that, and those who are familiar with Islamic products and Islamic contracts will know that those primary elements of the contracts are already incorporated there.
So this legislation is not in itself a isolated case. It still have to be subjected to the Sharia laws, right?
No, it's Sharia law doesn't apply in Hong Kong. This is the law in Hong Kong, and what it's done is it's incorporated the primary elements, but it doesn't say that Sharia law shall apply.
But this would the Sharia law would apply to the products, would it?
In essence, anybody wishing to come to Hong Kong and create a product would look at the ordinance to seek the specific exemptions, because in having an Islamic contract, you need a number of steps, because Islamic contract, in a finance, you just have a loan and you have interest on that. But for an Islamic contract, you need to have a number of steps, for instance, trade in a product being sold back and forth, and that creates, under our present ordinance, liability to tax. And what this does is remove that liability to tax for the specific purpose of that trade which is required to make finance possible. So Islamic finance is not actually finance as in banking finance, but requiring banks to become traders in effect. And therefore it allows for that particular exemption for the particular tax that would arise in Hong Kong. And I'm quite happy that it's neutral, because within Islam there's so many different schools of law that one school may disagree with another school, and it's not really helpful to have all of that within our structure, and therefore the neutrality of it is actually quite useful to everyone.
That's what. Sorry. My understanding, which limited understanding, but the Islamic laws is infiltrated into every part of one life. How can a legislation be neutral of this Islamic law? Is that my understanding is wrong?
Well, Islamic law, as far as Muslims are concerned, it affects him in every aspect of his life, and Imam Murshid is the scholar on that.
Yes.
But as far as others are concerned, it is no more than, for those who are non-Muslims, is no more than somebody, an institution saying, well, we want to invest in socially responsible investing. So that means we don't want tobacco, we don't want alcohol, we don't want, and so somebody investing on that basis would be very close to somebody investing on Islamic principles, except that they've got additional elements of interest involved in it.
Yeah, the reason why I want to ask is just we want to go in with our eyes open rather than just that we like the products and we can accept a lot of things which we don't understand.
Yeah.
And that's the whole purpose of today's meeting here, so that we can seek understanding from the enlightened ones.
Yes. I hope my answer have enlightened you on that.
Mr. Ahmed.
Yes, I just want to elaborate that for any specific transaction that would incorporate the provisions of this bill, there would actually be transaction-specific documentation. That documentation would benefit from providing tax neutrality effectively to Islamic finance as compared to conventional. So this really serves to level the playing field for Islamic finance transactions to be no more expensive than conventional transactions from a taxation point of view. The governing law of any particular documentation would be either the local law that is recognized in the jurisdiction, or it could be international law. For example, it could be English law or the law of any other internationally accepted jurisdiction. The approval process for a particular transaction document would involve going to certain internationally recognized, well-renowned Sharia scholars. So they would look at the particular structure, they would look at the documentation, and notwithstanding the fact that the governing law could be English law or Hong Kong law, they will evaluate the structure and the documentation under the principles of Islamic finance. And if they believe that the structure and documentation complies with the principles of Islamic finance, they will approve it to be Sharia compliant. But the documentation doesn't need to be governed by Sharia law for them to do that. And therefore, what we're really doing here is providing the enabling legislation for transactions to be structured such that they can then be, compliant both with the relevant governing law as well as the principles of Islamic finance.
Thank you. Then my next question is, have there been any cases in other jurisdictions where such alternative bonds took place, that there have been a non-compliance to the Sharia laws that eventually end up in court, that this would put the investors into a rather embarrassed or a disadvantaged position?
I think there's,
yes. Mr. Edigo, you want to
add? I'm not sure whether I can answer your question exactly, but I will try to bring out 3 cases for your reference. First of all, London, besides Malaysia, London and Dubai is another 2 key Islamic centers. And according to the, I remember that according to the law in London, they still adopt the religion-neutral approach. I think from government's point of view, there's no ground to impose Islamic jurisdiction into their laws. And in Malaysia as well. And that's why I just proposed IRD to include a SARA member into their department and in the committee and DIPN. This is the first point. And second one, I read from there are 2 business cases. I think more than the deal structure, if the Islamic bankers or other bankers, they want to deal with their investors or try to arrange some kind of Islamic financial arrangement to their investors, they need to include professions from SARA bodies to comply SARA principle. I think that's something on top of government jurisdictions. The first case is Normuller's case in Labuan. So the Normüller tried to rearrange the deal structure from a conventional deal structure into an Islamic deal structure to, with an opinion from SARA bodies. So I think that you can take this as a reference for that. And second one is Esther, AXIATA. That's related to the listing one, stock code 4320. They use the airtime, they are mobile carrier, they use the airtime as an undertaking to arrange the deal structure to issue Islamic sukuk. So I think I cannot, this can answer part of your questions.
Thank you.
Okay. So I think you might be interested. There was a case in England, Bexingco and Kuwait Finance, I think, which one of the parties, having taken a loan in Islamic finance, then said, well, this is not in accordance with Islamic law, and tried to introduce that, and the court said it's not the application of Islamic law, it's an application of contract law. Therefore, you can't actually incorporate Islamic law into our laws just because you're incorporating some of the elements. And in fact, in Malaysia, there was a case where the judges tried to interpret Islamic principles within the judgment, and I think they changed the rule now that only Bank of Negara has a special interpretation unit which will interpret Islamic principles for the purpose of those products rather than the courts And so even in Malaysia, they've addressed that. So it's not going to be, and I've not known of any other country, not even Pakistan, unless they have a specific Islamic court where they can impose Islamic law. Because it's not really certain which Islamic law would apply, because actually there are 5 schools of thought. So I know there are countries like India, Pakistan, Singapore that do have Islamic courts in relation to certain parts, but then those are well defined and set out. So there's no problem about incorporating Islamic law into a common law country. Because even if we were to follow being a common law country, looking at Malaysia, they haven't got any authorities that we could adopt because Bank Negara has taken over that.
Yeah, sorry, Chairman. My limited knowledge and my ignorance actually put me into this number of questions. That under the common law, we enter into a contract. If the contract, the product that we enter into that contract, that product is subjected to Sharia laws. The Sharia law is an interpretation that could be open because there's no, as you said, there's no law. So when you enter into contract or something that is wrong, doesn't make the contract right. That's my
that was covered in Beximco. So if you read the Beximco judgment and Kuwait Finance and Kuwait Bank, then that's covered in that. And as I said earlier, and the courts haven't incorporated Sharia law into contracts. And in fact, that's good. And I think you've covered some aspect of that.
Mr. Ahmed.
I think the key point is that the governing law of the contract is not Sharia law. The contract complies with the principles of Islamic finance, but the governing law is still, common law or English law.
Thank you for your explanation.
Okay.
Thank you.
Mr. Asad?
Yes, actually, it is just the facility or opening a window for those who want to make their business according to their religious requirement. So it has no contradiction with others, or it is not taking out from the overall laws of the country or the finance law. So just it is a facility, I believe, for those who want to deal, or even for the investors who want to keep their investments safe. So this is one of the way that they can deal through Islamic finance.
Thank you.
Mr. Edigo?
One point, additional point to Mr. Nasha, or maybe part of the answer to this gentleman. So Malaysia adapt a common law, and so Pusha Malaysia, and they adapt, they are onshore. But we Labuan, we are offshore, and we adapt a common law as well. But we have additional legislation, Islamic legislation on top of Malaysia. So I think that I agree that this gentleman that both would not be contradicted. So because the one who arranged the deal would look at both law at the same time. Yeah.
OK， 李慧瓊議員，你係咪有問題？冇問題啦，係嘛？梁繼昌議員。
多謝主席。I just want to follow up these legal issues. Now, although I understand that in interpreting the transaction documentation, it is the governing law, it's either sometimes English law or New York law, which will be relevant for the instrument. But I hope, the influence of the Islamic law is still there. I hope I can answer Honorable Abraham Sheikh's question. For example, if you got a silk code, I think the issuer would invariably appoint a Sharia committee, and that is a specified committee with scholars sitting there. And I do think, invariably, I think in these transaction documents, either as a termination event or event of default, if the Sharia committee rules that the product is no more Sharia compliant, is my understanding correct?
Yes, so if the products are usually structured on the basis that they receive approval, being Sharia compliant. But there is, within some products, there's flexibility as well from the Sharia. As we said, you've heard the 5%, the 1/3 rule, 5% rule. They apply in different levels and also different schools. So, yes.
Mr. Chong.
Just to add from the various discussions, and again, when you look at the governing law of the contracts, and also for the sukuk, for example, it's either, if it's international, it's English law, New York law, Malaysian law, Singapore law, for example. Getting the Sharia opinion is one aspect of it, and that's a deliverable for the bond offering itself. And the Sharia opinion itself is relevant for investors who require them, and this will be investors who are Islamic investors. So it doesn't preclude conventional investors from investing in this sukuk as well. So from that perspective, you know, non-Sharia compliance at the end of the day is not an event of default, because the bonds was, the sukuk themselves was carry on as an instrument for the 5 years or the 10 years that they are issued for. So the delivery of the Sharia opinion is just one aspect of that. And to gain the broadest base of investors, the arrangers of these bond offerings will use a panel of internationally recognized Sharia scholars to provide their pronouncement, so that the investor base can actually, as broad an investor base can actually buy into these products. Yeah.
Okay. Mr. Ahmed.
Usually depending on the kind of product, there would be provisions built into the contract that are meant to ensure ongoing Sharia compliance. Mm-hmm. So for example, if a contract is structured against a pool of real estate assets, if there is a need to dispose of those assets for some reason during the life of the sukuk, there would be a provision in the contract that provides for a replacement of those assets with other Sharia compliant assets, so that underlying lease arrangements can essentially continue. So, you know, that should ensure that Sharia compliance is not at risk on an ongoing basis, as long as the conditions of the document are met. Secondly, I think it's important to realize that Islamic finance has been evolving over the last couple of decades and will continue to evolve. And new instruments, new types of underlying assets have come into the fold. There are, however, no precedents of a previously approved Islamic transaction being declared to be non-compliant by the scholars with retrospective effect. So even though new forms of Islamic contracts have, or application of Islamic contracts have been introduced, for example, the first sukuk was only done on the basis of a sale and leaseback structure, but now there have been several other types of structures done. That doesn't mean that what's been done in the past has been effectively, you know, renounced in any way by the scholars. There are no precedents of that having happened.
I just want to have one follow-up question. Although I think Mr. Chong has rightly pointed out that the non-compliance, I mean the compliance process is a continuous process, right? Although Mr. Chong has pointed out that the non-compliance, for example, during the term of the instrument is not an event of default, but commercially speaking or practically speaking, what implications it will have if during the term of the to the investors, of course, I'm talking about the protection of investors. What legal implication or practical implication would it have if the instrument during the middle of the term is not Sharia compliant? What will happen, in fact?
Mr. Nasser?
In part of the amendments that I suggested, I had put in certain aspects where there would be replacement of the product. So where you get a situation of that nature, it's within the experience of those formulating it to be able to change product, replace product. So it's not unusual if it's right. But usually these things are considered well in advance anyway. But if an event should arise, then you can replace product. And I've suggested that within the amendments.
Jiang-san?
Yeah, sorry, just to reiterate, when I talk about non-compliance effectively, as mentioned, as explained, within the documentation itself, right, it does provide for, the assets to be able to be replaced. So if for whatever reason the assets become non-compliant, right, the issuer has a right to be able to replace those assets, and it's an undertaking that they have to replace those assets. So to date, we haven't seen any non-compliance from that perspective. That's why you don't build into the sukuk structure itself an event of default from that perspective, just because it's a Sharia non-compliant, because it's provided for in the contract itself.
OK， 好，冇其他問題啦嘛。OK， 就石禮謙議員。
I'd like to follow up with the question that the right of replacement is on the not to the extent that this could disadvantage the investors. Is there any protection for the investors when there have been a change of products because of non-compliance? I'm talking on protection of the investors.
邊一位可以答 ？Mr. Zhong。
Yeah, it will be the same type of product. So if it's a sale and leaseback, for example, generally it will be the sale and leaseback as well.
When there is a value change, value can go up and value can go down.
Yeah, but it has to be of the same value.
Then it went down. This means that there has been effect on the product, on the contract. I mean, have I made myself clear?
No, just to complete, it's the replacement of the same value.
Okay.
Right, so you're not replacing something which is more inferior.
Thank you.
Okay. Mr. Ahmed.
I think it's important to make the distinction that investor protection in the context of ongoing Sharia compliance is different from the value of the investment. So I think this is exactly the kind of risk that we have to be mindful of, that sometimes if investors are losing money on an investment, they may want to consider, whether there is any way to sort of seek recourse on the grounds that an investment has become non-Sharia compliant. So as far as Sharia compliance is concerned, as long as the asset is replaced with a comparable asset in case there is destruction of the asset or that asset needs to be taken out of the pool for some reason, then Sharia compliance on an ongoing basis is ensured. Now, what we ensure in these sukuk bonds is that every investor has the opportunity to look at the certification of the structure that has been provided by the Sharia scholars. And based on that, the investors make the determination of whether they are comfortable with the disclosure of the nature of the underlying contract as being Sharia compliant from their perspective. So by investing in that transaction, they are acknowledging that they understand the structure and they accept the fact that it is considered to be Sharia compliant from their perspective. So to the extent nothing changes in the fundamental structure, if they change their view, that doesn't necessarily mean that the underlying structure has become non-compliant at a later stage.
Thank you for this detailed explanation. You see, the reason why we have to ask so many questions, because we are legislating in uncharted waters. A lot of things that this is something new to us, as to me. I think it's something that is very important that we know exactly what we are legislating for. Not that we don't trust government, that we are here to check on the government, and we just want to know how much they understand this, so that as legislators we have to ask all this question. Possibly we haven't asked enough because we don't know what to ask. As I said, that these are all uncharted waters, and it's very important that we must need to know. Thank you.
Absolutely. Thank you.
I just want to add that we shouldn't penalize Sharia financial products for being non-Sharia, running the risk of non-Sharia compliance, because actually deep down we're talking about governance issue, and conventional financial instruments have the same issue. So I think just want to bring that point up.
But it's slightly different, because you're talking of ordinary financial issues or products, whatever it is, but they are not subjected to some form of religious laws. All these religious laws are different from other products, which are all commercial, based on commercial principles, based on commercial understanding. Religious law is beyond human understanding of the ordinary people, because it's based on a number of Sharia scholars. The scholars itself, as explained to us, there are 5 different schools, and that 5 different schools could come into different interpretation. Like even in Hong Kong with the basic law, when we have problems, we go to NPC, the National People's Congress, to seek interpretation. But our interpretation rests on the 5 scholars. That scholars, their thinking and the religious belief is different. So that's why we have to be so careful. There's a lot of other people's money putting into an investment. Not that we don't trust this particular instance. We need to understand more. That's all.
Mr. Asher?
Yes, actually there are 5 different school of thought. But in finance, there is only one school of thought. They are all 5 agreed. And you can see the same finance in Iran, same in Dubai, same. Actually, there are different school of thought that is not related to finance. There are other issues, other practical, other ibadah, like worshipping, like punishment, some others. But in the finance, there is consensus, and there is agreement among all the scholars. So I believe there will be no problem in this field.
嗱，我哋延長嗰個會議嘅時間呢，係去到10:45啦，好嘛？因為大家都好踴躍，去到幾點鐘？係咯。Mr. Nasser, you want to respond?
I think it might be easy to understand in the sense that as far as Islamic finance is concerned, it's basically the Islamic rule is everything is determined by contracts and agreement between the parties. So it's primarily a question of contract. The only thing where Islamic law applies is in the prohibition, what you're not allowed to do, which is basically, as Imam Arshad said, uncertainty, gambling, interest. So one really looks at what is not allowed from the Islamic principle rather than Islamic law as such. It's only what is not allowed, and that's those few elements.
Okay, Mr. Edigo?
I just want to mention that, but mentioned already. I think the key is the deal structure, and the key is the lawyer and the banker. And that's why we adopt a religious neutral approach, for fear that the religious law will supersede the common law or contract law. And the other point I want to remind the IRD is in my my opinion to the consultation paper. I remember that there would be at least 11 kinds of different kinds of sukuk in Malaysia, and four a popular one. So if I would recommend you include these 4 cases or in your SARA members or opinions in your DIPN. Because these 4 are most popular one.
Okay, thank you. 謝禮議員，仲有冇咩跟進？冇啦，唔該。好啦嚇 ，OK， 好啊。阿梁議員。
Just one more follow-up question. In case there are new sukuk products to be included, I just want to clarify, it would be included as a subsidiary legislation, or could it be included in the DIPN itself? Maybe the government can answer this question.
殷小姐。
Is to include it as a piece of subsidiary legislation that the financial secretary can move for negative vetting by the legislative council. So I guess that the DIPNs can also supplement all the other administrative details with regard to interpretation and so on. But then if an expansion of the coverage is required, we usually we propose to do it through the making of a piece of subsidiary legislation.
好啦，冇其他嘢嚇。
冇其他嘢啦，主席。
咁我要喺度咧係再一次多謝咁多位團體嘅代表出席今次嘅會議嚇。你哋係提供咗好好嘅意見嚇，不管係喺市場裏邊嘅專業嘅睇法，或者係喺我哋草擬呢一個法例嗰方面咧，都提咗好有用嘅、有建設性嘅意見嚇。咁喺處咧係多謝你哋嘅出席，好嘛？多謝晒。今日你哋就因為跟住落去，我哋仲有處理其他嘅事務，好嘛？多謝你哋出席嚇。各位同事，就我哋上一次討論嘅文件裏邊呢，仲有一份呢係要跟進下嘅嚇。咁就係文件呢 CB 16931213 13號嘅文件。咁或者副秘書長你做一個簡單嘅介紹好嗎？
好啊，多謝主席。我諗剛才嗰個同業界啊同埋與會人士嘅討論都可能有啲牽涉我哋文件嗰個一啲範疇啦。咁主要喺上一次個法案草案委員會呢，就問到關於我哋喺收集即係嗰個公眾諮詢意見嗰個結果。同埋咧，就係話即係啲其他司法管轄區喺呢一方面嘅發展嘅做法，同埋好似頭先其實個討論都有大部分涉及咧，就係話伊斯蘭債券喺內地金融市場嘅投資環境，或者係啲嗰啲人民幣啊，或者係嗰個主權基金方面，或者我睇睇其實第3點喺頭先都有相當嘅討論，或者我只係補充於關於呢我哋喺嗰個公眾諮詢收集翻嚟嗰個意見嗰個結果方面嘅問題。當然頭先都有與會者就提出咗，包括嗰個涵蓋嘅範圍方面，咁我哋都係有積極回應啦，加翻咗個代理安排啦，同埋喺嗰個草案裏面呢，就係有啲彈性，在日後有個機制去增加呢個其他嘅種類嘅。咁就最緊要呢，就係有一啲喺符合嗰個喺嗰個稅務方面呢，因為個伊斯蘭債券嘅產品嘅結構係比較獨特啦，但係而家我哋希望佢能夠喺各種稅務方面有啲豁免，變咗喺嗰個彈性便利市場發展同埋一個即係稅務嗰個執行上面呢，都係要攞啲平衡嘅。咁當初我哋譬如喺嗰個最長年期呢，最初我哋嗰個建議呢，就係話嗰個伊斯蘭債券呢，最長個如果個產品可以到10年。咁但係我哋都收集咗一啲市場嘅意見啦，覺得仲可以俾多啲彈性嘅處理。咁我哋呢度亦都係相對調整咗呢，就係而家係法例之下呢，就話可以唔超過15年嘅。如果佢係要係即係話受惠於呢啲咁嘅稅務嘅寬免。咁就譬如另外就係話，譬如記錄嗰啲備存嗰個時間呢，以往亦都係比較係嚴謹，超過10年咁樣。而家係我哋修訂係一個比較相對寬鬆嘅做法，就係話喺嗰個事件發生7年或者係嗰個成個嗰個產品呢，嗰個年期完咗之後3年咁樣樣。咁都係有一個寬鬆嘅處理，其他有啲我哋原底要求嘅呢，我哋都係刪除咗嘅。咁當然啦，對於即係所謂嗰個合理嗰個投資回報呢，咁呢個呢，其實日日都係取一個平衡，因為鑑於呢個產品嗰個獨特嘅性質，佢係一個債券嘅，但係亦都有其他嘅債券種類，譬如股本嘅債券嘅安排。咁但係我哋亦都係吸納咗市場嘅意見，就希望喺嗰個草案法例下邊訂立大原則之餘呢，喺嗰個稅務局長嗰個執行指引嗰度呢，係會更加有多啲清晰嗰個一啲係所謂指引俾市場人士去參考嘅。咁呢度我相信可以仲有空間係稅務局長同市場人士係有啲討論。咁但係我哋覺得係用執行指引嘅方式嗰個表述呢，係比較實際上嘅執行係仲便捷啲嘅，對於市場人士嚟講。咁所以我諗總體個回應，我諗係就住呢幾點嚇做咗。
好啊，
多謝主席。
同事有冇咩問題啊？嗱，如果冇問題嘅話呢，就我哋處理咗呢一份文件，咁就我哋下一次嘅會議呢，我哋先至去做呢個逐條嘅審議嘅工作。咁我要提一提大家嘅呢，就係我哋就預備咗幾個時間呢，係作為我哋下一次審議嘅會議嘅時間嘅。咁就係2013年4月5號，請大家記低好嘛？4月5號就星期五下晝2點半，4月15號星期一下晝4點半，同埋呢係4月30號嘅上晝10點半10點9，好嘛？嗱，我會再進一步問呢，就係即係其他啲同事，因為今日有好多同事都冇出席。4月5號呢，有可能有啲同事係未必喺香港，但係我會問咗先，好嘛？咁初步定呢，就4月5號 下晝2點半但係我會再問問其他同事咧，因為如果到時候，因為我哋要有個 quorum 嘅今日而家我哋得3個同事喺度咁我就會再問問梁繼昌議員。
主席啊，你諗住係每一個議程嗰度係大概幾耐啊？嗰3個會議，你講緊有
咁難都係2個鐘頭啊！2個鐘頭，每一節都係2個鐘頭嘅。
OK， 得，
好嘛 ？OK， 咁就我哋會確定咗個時間咧，會盡快通知政府方面好嗎？咁我宣布今日嘅會議咧到此結束，多謝各位。